So we have a client at Bold who I spoke with a little bit earlier this month. He had a business years ago and he went to market, created a brand, right? Was successful in that brand and then slowly kind of lost interest in it, but still maintained some, websites and things like that. Well, someone in China took his brand and all his images and logo, pictures, all that sort of stuff, reopened the store on Amazon and has been running the store, selling,
Whoa,
selling hundreds of thousands of products.
that's crazy.
Crazy, right?
Whoa.
So yeah, so we're gonna be dealing with that, which is really interesting. But I've never seen such a brazen ripoff of a brand before.
I need to register
Oh,
trademark for a martial arts system,
yep,
but everyone says get a lawyer. No, listen to them. I don't have the money right now for a lawyer. Is it possible to do it myself through the USPTO? What about internationally? Would you be
sure.
able to use the name worldwide, like the protection beyond the US? Is that possible?
Yeah, we have a number of martial art clients that we work with. But so yeah, you can basically register the education, training, martial arts services that you provide under your moniker, right? So whatever your studio dojo name is, right, you could register that name potentially if it's not already been registered or something similar to it with USPTO. Do you need a trademark attorney? No, you don't technically. If you have the money, yeah, it's probably a good investment, right? I think we can provide a lot of good value for clients. But there's a lot of folks who file the trademarks without attorneys. I know from experience that the success rate of those clients is much lower than those represented by a trademark attorney. But there's many clients who get through the process by themselves. So if you're willing to dig in for a few hours, kind of learn how to fill out that form, find some good answers maybe on this podcast, and yeah, you can certainly file it yourself.
Yeah.
Now, if you don't have money for an attorney, you're definitely not going to have money for filing abroad because that gets crazy pants expensive. So
Okay.
I just quoted a client this morning to file in the UK, and whereas right now it's 250 going to 325 next week here in the US, it's like $950 in the UK. So it gets crazy expensive when you go abroad.
The USPTO trademark filing fees per class going from what to what?
250 to 325. No, I'm sorry, 250 to 350. Excuse me.
Oh, that's a big jump.
That's a jump. I'm
Yeah,
still
really.
learning. I'm still learning here on the
Yeah.
new price. It's funny, I spent my career, last 13 years, memorizing all these weird random numbers, right? For
Yeah.
cancellation, opposition filings, petitions to revive. I mean, Section 8, Section 9, 15, all these different numbers, right? And now I have to relearn them.
They're going to redo all
My
that?
brain, JD, is not as
Nah.
soft as it used to be, or it's very smooth these days.
Gosh. Well, the USPTO may be increasing by what appears to be almost 40%.
hmm
Bold IP, bold patents, we're not going to raise prices a bit during
Yeah,
this
brother.
time frame.
Let's do it.
Okay?
Let's not do it.
We're here for you, the trademark, aspirational business owner, entrepreneur. So let's hope that money goes to good causes. Hopefully, get that trademark pendency down.
Oh
My
gosh, yeah,
goodness.
wouldn't that be great? I hope that's what they're doing with it because
Yeah.
folks who filed trademarks recently in the last 4 years know that it's gone from like 3 months to first examination to 8.5 now. I think it's come down to 8.5 from 10 months.
Okay. Yeah.
Still too long though. But yeah, it is a significant price increase. So
Yeah, it is. That is. It is. The last part of that question, I want to make sure we catch. You mentioned internationally is expensive.
yeah,
Now, like patents, I assume it's the same on trademarks where there is no worldwide filing.
correct.
You've got to
Correct.
file discrete countries. Is that the
Yeah,
same?
that's
Okay.
right. So you will get like an international trademark registration number,
Okay.
but it's only valid in the countries in which it applies to, right? Or it's been registered.
Okay.
So
Got
a
it.
lot of times, I'll come across folks who might have an international trademark registration number, right?
Okay.
But it's only in Canada. It just depends on how the trademark was filed, where it was filed, when it was filed. Did they use the Madrid Protocol? Did they go through WIPO? Lots of reasons why you might have an international trademark that only applies to a couple countries. It's expensive out there. I mean, if you go out to UAE, I just submitted a couple applications for a client to UAE, and I believe it was $5,000 in legal fee, in government fees.
Government fees. Wow.
Yep.
Goodness. Well,
Something
one.
that's like close to $2,500 per trademark, something like that, I believe.
Okay. And that's not legal fees. That's the administrative.
Yeah, that's just government
Fees.
fees. I mean, I think those were more than the legal fees, to be totally honest.
Yeah, it sounds pricey. Is it possible, realistic, to obtain a design patent with the USPTO for a product like a form-fitting silicone cover for a portable audio device that was patented by someone else? Interesting.
Hmm.
New product cover follows the contours of an existing design, but differs in color, texture, and several other characteristics.
This is
Wow,
a great question.
you got to be real careful here, I think. Um, you want
Secret
to.
counsel, maybe an opinion, maybe an infringement opinion.
I think the first order of business would be to make sure that you're looking at the product. If it's a specific product, let's just say a classic example might be AirPods, right? It's an AirPod cover. I'm imagining that. Okay, let's use that as an example. Apple's got several patents, both utility and design, covering the AirPod Pro, right? The actual structure, the way that it looks three-dimensionally from their own design. And I think if you're going to go produce a product that's kind of the inverse of that design, kind of like the cover, the anti-design, you'd want to make sure that you are not going to be infringing. I need to approach that. It'd be the first time I think I've ever done it, but I think to offer an infringement opinion on that shape, so long as it's not going to be anything that even looks like an AirPod or the actual device that's patented, and so you'd have to have it. You'd be disclaiming, obviously, anything underneath, anything looking like an AirPod. It would
Right.
just be the cover. And so I think as long as it remains a cover, it's possible. But again, to get a patent, you've got to be able to show that it's novel and not
Right.
an obvious version of something that came before it. And I think the fact that have knowledge of the actual shape that you're forming it around, that design has been out there. You'd have to show some other way, three-dimensionally, that you're
Mm.
changing that design substantially, so that it has other elements, folds, flaps, ridges, different type of aesthetic than what's underneath it. Otherwise, it is
Sure.
purely prior art.
Well, what about this? So JD, like I'm thinking just of the patent drawings that we've looked at in the past. You have the solid lines, which is what you're claiming as a feature
Yeah.
of the patent, right? And then you have the dotted lines. Would potentially the inside like design, look or be in dotted lines essentially because it, is not being claimed? And if so, does that potentially get around the design patent? I
Yeah,
don't know.
yeah, you would not want to. So by not claiming, you would have it in dash lines. I think it's valuable to show the environment in a
Mm,
design patent. That's all you own is the drawings.
right.
And so
See.
clearly showing at least one embodiment where how you would put that silicon cover, on is important.
Yeah.
But no, you're by no way saying it's only for that one product. It's just a one embodiment. I think as long as what was in solid black line, based on some research we would hopefully do, you've got some ability to demonstrate that you've got novel features or elements.
Sure.
And if you think you do, I think it's perfectly fine. And one other cool, interesting, maybe not so cool for this person asking the question, but the patent office will issue a patent on a novel design, but it might infringe, let's say, this other
Sure.
product. And so you got to be careful. What are you getting a patent on? Can you commercialize it? The patent office is not going to do an infringement opinion for you.
Yeah, it's the same on the trademark side, right? I think clients often confuse with the registration process with the infringement process,
Yes.
right?
Yes.
So registration, like different standard as compared to the litigation side, generally a
Yep.
lower standard, to be completely
Yep.
honest.
Kind of somewhat off the cuff answer is I don't think there's going to be a lot of trouble in terms of infringement. I mean, there's a lot of those type of devices. Think of all the cell phone covers and third party
Oh
accessories.
yeah,
And as long as it's not actually you're not selling it as as an audio device, it's a purely a cover, an attachment, an accessory.
hmm
I think you're going to be okay.
yeah. I would think from like a I don't know, public policy standpoint, you'd want folks to be able to register these types of designs, right?
Yeah, yeah, yeah. I think there are. I mean, I'm not in the industry, but I'm sure there are. You always see those leaked Apple updates. When the new iPhone's coming out, because the
Oh
people
yeah,
that
I heard at CES someone had like a Nintendo Switch 2.
sure, yeah. I mean, there's all these kind of developers that or accessory makers that actually will get advance notice of what the dimensions will be, so they can start making those new designs for the covers. And there's a whole industry out there like it, but it does rely on some level of trust and
Mm.
confidentiality. Um, but it's human nature to.
Hey, I got a quick story to tell you.
Okay, go ahead.
So we have a client. at Bold, who I spoke with a little bit earlier this month, he had a business years ago, and he went to market, created a brand, right? Was successful in that brand, and then slowly kind of lost interest in it, but still maintained some, websites and things like that. Well, someone in China took his brand and all his images and logo, pictures, all that sort of stuff, reopened the store on Amazon and has been running the store, selling,
Whoa,
selling hundreds of thousands of products.
that's crazy.
Crazy, right?
Whoa.
So yeah, so we're gonna be dealing with that, which is really interesting. But I've never seen such a brazen ripoff of a brand before. We're trying to figure out what to do and if it's worth investing in the legal resources necessary to, potentially get the Amazon store back.
Yeah.
Right. I mean,
Right.
that would be pretty cool for him. If he
It
could
would
get
be.
that storefront transferred back to him.
But there's
But
likely no recovery of damages or who knows what.
yeah, I mean, I think it's gonna be really hard to potentially, you know, file a lawsuit against someone in China, right here in the United States. I mean, you could get a default judgment. You could probably get the money from the Amazon account. There's like an Amazon account where they keep basically the last 6 weeks worth of sales.
Yeah.
So you can probably get that from damages, but that's about it.
Okay. Well, it'd be cool to kind of hear how that shakes out.
Yeah, yeah. I'll be curious, Jay. I really hope he wants to move forward with us because that'd be a fun project.
Yeah. Can I trademark a business name that is basically my first name plus a descriptive name of what I'm selling? It's an online only business. I'm selling mostly through eBay and on my own website. For examples like John's Bicycle Shop, it's well known for a niche market, but still a home based one person business. Is this something that's very unlikely to be approved because it's descriptive? If yes, do you think it's a 50-50 shot? If I'm unable to
Yeah,
find out. Yeah, what do you think, Matt?
that's a good question. Let's do a little bit of on the fly research. How's
I
that?
love it. Yeah.
I'm thinking specifically, I mean, the bike reference is kind of apropos because we have a company here called Eric's Bike Shop,
Okay.
and they're pretty well known. And you can guess what Eric's Bike Shop is pretty
Bike
easily, right?
Yeah. Very
Yep,
descriptive.
pretty descriptive. So it is registered at the USPTO on the principal database.
There you go.
So generally speaking, the answer is no in my world for a couple reasons. One, it's going to be almost impossible to enforce. It's going to be very difficult to get the trademark too. But um, I want to look and see really quick if there was any pushback on the application. Bike shop was disclaimed. So he still had to enter the bike shop, but he was able to register Eric's
Eric's with the apostrophe.
with the apostrophe.
Okay.
Um, that's pretty wild to me. I mean, it's a pretty well-known company, so I want to look at one more thing, and
Yeah.
maybe that'll give us a little bit more. Oh yeah, so they go back to 1977.
Okay, so they've had some secondary meaning, no doubt.
They
That
got
it's applied.
secondary meaning. Look at you, JD.
Yes.
Secondary meaning, acquired
Ooh.
distinctiveness, 2F
Okay.
amendment.
Yes.
Yeah, that's great. So yes and no. You got to be pretty gosh darn well known to make this work for yourself, both from
Okay.
a sales standpoint and a trademark registration standpoint.
So likely not a 50-50, more like a 0.5 to 100. And
I
then
would do whatever I could to get the client to change their brand.
Okay, good.